Discovery is FRCP 26-37, outlines the formal procedures to gather evidence before trial. Otherwise limited by court order, the scope of discovery is as follows. This is the Discovery General Standard. A party may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance to the issues at stake in the actions, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Discovery allows parties to request access to docs, tangible items, land, and electronically stored information. If the other side refuses to allow access or produce materials, the court will step in and back up the request as long as the discovery is relevant. Discovery can be requested from a third party. In the discovery, you can ask questions and receive answers in writing. These are interrogatories. Requests for admissions or denials in writing. Information obtained from this form of discovery, the request for admissions or denials in writing, is deemed admitted and conclusory. All other types of discovery are considered evidence, not necessarily fact. And of course, live interrogatories, which are depositions. Discovery is cost prohibitive, and if all facts are revealed during this phase, settlements can result. Discovery, which is the formal fact gathering, can be supplemented with informal fact gathering. Informal fact gathering must be done ethically, no lies or deceit. Private eyes are also bound indirectly to ethical rules. Rule 26, the duty to disclose, general provisions governing discovery. Rule 26 sets forth two basic stages of discovery. The first stage is mandatory required disclosures. The governing standard here is to only reveal things that will help and not hurt your case. For mandatory initial disclosures, you would reveal the best information up front. This occurs within 2 to 3 months of the lawsuit. There are 4 types of initial mandatory disclosures. Number 1, the name and, if known, the address and phone number of each individual likely to have discoverable information, along with the subjects of that information, that the disclosing party may use to support its claims or defenses, unless the use will be solely for impeachment. Number 2, a copy or description by category and location of all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control, and may use to support its claims or defenses, unless the use will be solely for impeachment. Number 3, damage calculation with supporting documents. A computation of each category claimed by the disclosing party, who must also make available for inspection and copying. This will be imposed on the plaintiff. Number 4, must disclose any insurance policy that could satisfy all or part of the judgment. This is imposed on the defendant. Plaintiff's coverage is not a mandatory part of mandatory disclosures. Here we have mandatory experts, expert witnesses. Their specialized training and knowledge allowed to give their opinion about the facts. They can give ultimate conclusions about the case. They can simply have a lot of familiarity with the topic. And there's a test called the Dober test to determine who is an expert. There is a distinction between testifying and non-testifying witnesses. Testifying, they testify at trial. There is a duty to disclose who the testifying expert witness is in discovery, in the initial discovery. Revealed towards the end of the litigation phase, 90 days before the trial commences. Name of testifying experts and detailed their elaborate written reports. After disclosure, the other side can depose. Tends to be the last major discovery step. Now we have non-testifying experts. Expert employed for trial prep only. These non-testifying expert witnesses are generally shielded from discovery if employed to just help with consultation and background information. Discoverable under exceptional circumstances only. If it is impractical for the other party to obtain facts or opinions on the same subject by other means, this will be the hardship showing. The case Thomas versus Haskell. The doctor was found via lawyer in anticipation of litigation. The doctor's report was discoverable because it could not be recreated by other means. In Chiquita versus Bolero Reefer. Consulting expert hired by plaintiff to inspect the crane. Bolero Reefer requested non-testifying expert report. He's non-testifying, so it's generally shielded and not discoverable. There was no hardship showing in this case. Bolero Reefer had the best access to the crane because they owned the crane. This was a free-riding attempt on the plaintiff's hard work. Now we have our mandatory pretrial disclosures. And those are very detailed. That is when you disclose every piece of evidence, every witness and exhibits, and this is normally 30 days before the trial commences. If the evidence is mixed or ambiguous, reveal just in case you need to use it later. If you fail to reveal it in the discovery stage, you cannot reveal for the first time at trial. Now we have the party-initiated discoveries. Types of party-initiated discoveries. We have interrogatories, requests for admissions, requests for the production of documents, and depositions. Party-initiated discoveries must be non-privileged, such as an attorney-client privilege, which protects private communications between a lawyer and client made for the purpose of giving and receiving legal advice. If discovery is privileged, the court cannot compel. Privileges don't seal the underlying facts. Those will still be discoverable. Pre-client conversations are also protected. This is the work product doctrine. The work product that is shielded or not part of the discovery must be in preparation of litigation. We have the Hickman standard. Discovery that attempts to obtain the mental impressions of counsel or to get the benefit of the other party's work via their work product without a showing of necessity would unduly prejudice and are not permissible. There's a general policy against invading the privacy of an attorney's course of preparation, and it is so well recognized and so essential to an orderly working system of legal procedure that a burden rests on the one who would invade the privacy to establish adequate reasons to justify production through a subpoena or court order. This zone of privacy helps maintain an orderly judicial system. An agent of the lawyer taking impressions is off limits as long as it was taken in preparation of litigation. Here's an exception. If you can make a hardship showing that you can pierce the work product, but mental impressions will be redacted. So some reasons for this hardship showing would be witnesses died or moved away, memories of witnesses forgotten, and pictures or video no longer available. Off limits. Documents and tangible things that are prepared in anticipation of litigation. But those materials will be discoverable if they are otherwise discoverable under FRCP 26B1, the general standard, or the party shows that it has a substantial need for the materials to prepare its case and cannot, without undue hardship, obtain their substantial equivalent by other means. Have to be relevant to claim a defense. If substantive law, they're relevant if substantive law says they're relevant. Relevance links admissibility to the substantive law and to common sense patterns of inference. Nothing is inherently relevant. It has to be proportional to the needs of the case. Considering the importance of the issues at stake in the action, the more discovery, the more important the issue. Added to counteract the monetary concerns, such as the amount in controversy, the party's relative access to relevant information. The greater the access to evidence, the greater the burden in discovery. 4. The party's resources. 5. The importance of discovery in resolving the issues. How central is the evidence to prove the issue? The more central, the more likely the discovery. Whether the burden or expense of the proposed discovery outweighs its likely benefit. There's a cost-benefit analysis. Proportionality is a multi-factor balancing test where no single factor is more important than any other factor. Rule 34 is document requests governed by Rule 26. There's a limitation on Rule 34. You are requesting items in the party's possession, custody, or control. One party may serve on the other party within the scope of Rule 26B. Rule 45 subpoena is to serve on a non-party. As long as you stay within Rule 26B, there's generally no limit to the number of documents you can request. Ask for documents in advance of the deposition. Rule 33, interrogatories. The party. It's another form of party-initiated discovery. It's written questions, and the responding party must give a written answer. Can only be served on parties. By default, limited to 25 written questions, including subparts. Parties can stipulate that they can go above 25 or ask the court's permission to go above. Interrogatories must seek relevant information, depends on the specific subject area of law, cannot be privileged, and must be proportional to the needs of the case. Again, that's the general standard for discovery. Rule 36, requests for admissions. This is party-initiated discovery. Requests written in writing to please admit blank. Other party can either agree or deny. There's no limit to request. Going to use with other parties to the lawsuit. When a party admits something, it is taken as established conclusively unless the court on motion permits the admission to be withdrawn or amended. All other discovery responses are evidence of what occurred and can be contradicted by other evidence. Rule 30, depositions tend to be saved until the later stages of discovery. Helpful to go through other docs and interrogatories before holding the deposition. It's a live interrogation under oath. The judge is not present. It takes place in a lawyer's office or the conference room. There is a 10 deposition limit per side generally, and it generally cannot exceed 1 day of 7 hours. It can go above if the other side agrees or is given special permission by the judge. Setting up a deposition for an individual. Reasonable written notice must be given. At least 30-day advance notice should be given. Notice is sent to the other party. The other party must attend. Setting up a deposition for a corporate entity. The notice of deposition must state the matters for examination. List of topics you want to examine. Company must designate one or more employees to testify on those matters. Amendment, this is an exception. This amends the general rule of notice to a corporate entity. You still have to give notice on a subject matter, but also meet or confer with the entity before or shortly after you send the deposition notice to discuss the topics. During the deposition, if the other party is asking inappropriate questions, an objection must be stated concisely in a non-argumentative and non-suggestive manner. Under the general rules, an attorney is not allowed to tell a client to respond to a question during a deposition. However, there are 3 exceptions in which you can instruct a client not to answer questions during a deposition. 1, to preserve a privilege such as attorney and client privilege. 2, to enforce a limit from a court order. And 3, the client must be subjected to tremendous harassment by the opposing counsel. And then you can tell your client that you are about to file a motion for sanctions for abuse. If there are no objections, state that the request inspection will be allowed. Rule 34, limitation. If you are requesting items in the party's possession, custody, or control. Here we have Rule 35, mental and physical exams. Rule 35. If a party is unwilling to submit to a physical or mental exam, a court can order the exam if there is a physical or mental condition that is at issue in the case and good cause has been shown. Good cause occurs if a party has put the mental or physical state at issue by seeking damages for mental or physical injury, or the party asserts mental incompetence as a defense to a lawsuit. This Rule 35 is not a self-executing rule like other FRCP rules. Rule 35 requires application in good cause. Discovery abuse, duty against spoliation. A duty against spoliation arises before the complaint is filed. Spoliation is the destruction or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. This is FRCP 37E. Upon finding prejudice to another party from loss of the information, the court may order measures no greater than necessary to cure the prejudice, or upon finding that the party acted with the intent to deprive another party of the information's use in the litigation, may presume that the lost information was unfavorable to the party, instruct the jury that it may or must presume the information was unfavorable to the party if the defendant acts in bad faith, or if the defendant has acted in bad faith, dismiss the action or enter a default judgment if the plaintiff acts in bad faith. If the duty against spoliation is breached, that can lead to dismissal of the case for the plaintiff, automatic verdict in favor of the opposition, financial, attorney's fees to pay for deeper digging of evidence. It's ultimately a wide variety of sanctions, and there's an adverse inference jury instructions. Materials destroyed, assumed evidence was unfavorable. Serious spoliation sanctioned. This is a rule from the case law. Dismissal or adverse jury instructions. But the party must demonstrate three things. A duty to preserve, when litigation becomes reasonably foreseeable. An example of that would be when a demand letter is sent. 2, the info was destroyed with culpable state of mind. Show intent, negligence, or intentional bad faith, at the very least negligence. 3, the info is relevant and favorable and supportive to the moving party. This is hard to show without actual information. You would need to have the information from someone who saw the documents or evidence prior to their destruction. If you can show bad faith for step 2, then step 3 is presumed to be true. This standard was developed for all types of materials. However, there are special provisions for electronically stored information. 26B, scope and limits. You must try to work out discovery fights in good faith before bringing them to the court. On motion or on its own, the court must limit the frequency or extent of the discovery otherwise allowed by these rules or by local rule if it determines that 1, the information is unreasonably cumulative or duplicative and can be obtained from some other source that's more convenient, less burdensome, or less expensive. The party seeking discovery has had ample opportunity to obtain the information by discovery in the action, or the proposed discovery is outside the scope permitted by 26B. Signed discovery requests. Signed discovery requests certifying that the request is proper and complete. If you violate the Rule 26G, the court has the discretion to issue sanctions under 26G, including attorney's fees. This sanction is immediate. 26C, protective orders. The court may, for good cause, issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following: forbidding the disclosure or discovery, specifying terms, including time and place or the allocation of expenses for the disclosure of discovery, and prescribing a discovery method other than the one selected by the party seeking discovery, and forbidding inquiry into certain matters or limiting the scope of disclosure or discovery to certain matters. Again, sanctions. If you fail to make mandatory disclosures, you may not use the information or witnesses that you failed to disclose at trial. Rule 37B allows the court to impose serious sanctions, but not until after the process. Objections. Objections can be included in the response. A party can object if they think a specific request is overly burdensome or not proportional to the needs of the case, or overly broad as it relates to time period. Must be objected to with specificity with reasons for the objection. If you object, you must state whether materials are being withheld. Other side will then determine if the objection is justified. If not a valid objection, they can ask the court to intervene and force the other party to produce the materials requested. If it is a very significant or sensitive issue, you would object and ask the court for a protective order based on harassment, which will prevent the other party from asking for that piece of discovery again. If you think the other party did not produce all the requested documents, you can move to compel, but there is a good faith duty to attempt to work out amongst the parties before bringing it to the court. If you request documents and the other party fails to respond, you can also move to compel, but again, there is a good faith duty to attempt to work out amongst the parties before bringing to the court. If a party requests documents that are privileged, explicitly claim the privilege and turn over a detailed privilege log which specifies the date it was written, who wrote it, who was the recipient, and the general topic. Once the log is turned over, the other party can agree and not fight, or if there's a disagreement, one party can move to compel or move for a protective order. The obligation is there to attempt to work out amongst the parties before bringing it to the court. If a party claims privilege but fails to provide a privilege log, courts have held that this failure waives the privilege. Evidence becomes discoverable. If you file a motion to compel and the court grants the motion, the court can grant the attorney's fees for preparing and filing the motion. Serious sanctions will arise if the party fails to obey the court's order to compel. Timing of discovery. To determine when the defendant was served with the complaint, when does the defendant make their first appearance? An appearance is when the defendant files anything in court, such as a motion to dismiss, an answer, or filing a notice of appearance. Then count out 90 days from when the defendant was served. Count out 60 days from the defendant's first appearance. Whichever date is earlier will be the deadline for a scheduling conference with the judge under Rule 16. Parties' attorneys will meet with the judge to discuss discovery matters, such as settlement mediation, when the case will be set for trial. Once the date for a scheduling conference with the judge is selected, count out 21 days before the Rule 16 conference. At least 21 days before the conference, parties must meet and confer on their own without the judge. This is a Rule 26F conference. In this conference, the discovery plan is created, discovery concerns are addressed, settlement is discussed, preliminary discussions of the case. The Rule 26F conference starts the clock for making mandatory initial disclosures. Mandatory initial disclosures must be disclosed at Rule 26F conference or within 14 days of the conference. Once the Rule 26F conference is held, party-initiated discovery is opened up. You can begin sending out party-initiated discovery requests. Exception: as soon as the complaint is served on the defendant, count out 21 days and the parties may begin delivering Rule 34 document requests to each other. All other forms of discovery must wait until the Rule 26F conference. The end date for discovery is typically set in the scheduling order that comes from the judge at the Rule 16 scheduling conference.